Monica Miller here. This is Legal Tuesdays, where I answer your questions about separation of church and state. The first question I will answer from our online web form is from an F.J. Jeskar, who says, in the 1950s, the Pledge of Allegiance was changed with the words "under God." This appears to be a blatant violation of the First Amendment committed by U.S. Congress. Why hasn't this been corrected? For one, I totally agree with you. It's an obvious violation of the First Amendment to have a federal statute that says this is our national Pledge of Allegiance, and they went out of their way to pass a law that inserted "under God" into a Pledge of Allegiance that didn't have "under God." Then they added God to our currency and then the national motto. This was in the 1950s, and it was during the McCarthy era. I actually did research directly on this for the lawyer Michael Newdow, who was, if not maybe not the first, but he was the main person who had challenged "under God" in the sense that he was the only one that brought it up to the U.S. Supreme Court. Just to backtrack for a second, I ended up reaching out to him while I was in law school. This was like sort of the start of my career, but I watched a documentary called The Pledge of Allegiance Blues, which I encourage everyone to watch. And this was after I started a secular law students club. And it really inspired me. And just that this man saw something was wrong. He's actually a doctor, and brought this case pro se. So it was a pretty remarkable thing that he did. And I said, hey, I knew he had lost the case at that point. And I'll pivot back, but he was in the works of bringing some more challenges relating to the pledge and some other stuff relating to God. And so he'd actually asked me to go, because I was in DC doing my internship at AHA, or I was about to. So he's like, when you get there, would you mind going to the Library of Congress and digging up all the American Legion magazines from the 1950s where they talked about this Back to God program? And it's not that different than what we are seeing right now with Project Blitz, actually. And I've never made that connection until now. But the American Legion had a very similar version of Project Blitz, and it was called Back to God. So that was sort of the impetus for, or at least the inertia for some of this legislation. Mike Newdow's daughter, I think it was his daughter, went to a public school in California, like a lot of public schools, where they say the Pledge of Allegiance. And so he challenged the fact that his daughter not being, he alleged that he's the father, he's an atheist, and that this, violates his rights as a parent, as his child's rights. Got up to the Ninth Circuit Court of Appeals. I think he lost and then he won. And then maybe he lost it. It's been a while since I know the case. What I do remember is that by the time it got up to the U.S. Supreme Court, they did not rule on the merits. They never reached the question of whether "under God" violated the Establishment Clause, because they said that the father didn't have standing to bring the case. And it was an unprecedented basis. And I don't think they've ever used the basis again. They made something up. I think one of the justices even referred to it as a ticket for one day, escape from confronting sort of what's at issue. Does "under God" violate the Establishment Clause? So on the one hand, it's kind of good they punted the issue, because it seems like when you read the opinion that they would have upheld it. So even like justices that were sort of concurring and they weren't sure leaned on the side of saying a couple things. So you had some justices saying, yeah, he doesn't have standing. If I were to rule on this case, I would probably uphold it, because God is just sort of this basic generic word, and it's in the context of a patriotic pledge. And so because our founders had, they cherry picked some founding fathers documents, and what they cherry picked in that case has been analyzed intensely by scholars, including Mike Newdow. Actually, I believe he wrote a law review article with Justice Scalia's name in the title. I'm totally forgetting it, but it was good. It's worth the read if you're really curious about this. It's a very bizarre ruling, but standing from where we are today, it's probably not the worst thing that they didn't rule on the merits. The only problem is that it's sort of dragged out, and we've been living in a limbo. And the problem is the folks on the other side, the Project Blitz folks, are aware that there isn't cases saying that it's unconstitutional. And so that's why we're seeing, and there was another question today about the Mississippi flag, and that's why we're seeing states push the boundaries, is because they know that there's no U.S. Supreme Court case that says "under God" or any of the God language is unconstitutional. Another justice said, it might have been O'Connor, that it was almost through the rote repetition from students saying it every day, that the duration of God being in it since the 50s was the reason why it had become neutralized. So it wasn't so much that there's a free pass for religion in this pledge because of history, which was some justices were saying the founding fathers, use the word God, and, so that therefore this is okay. Other justices were saying, well, if we were to uphold it, it would be because it's just neutralized by time. So it's not even a religious word. And what I would say to that is that's sort of the error of thinking by a lot of Christians, is that these issues are atheist versus religion, like theists versus atheists. And the truth is that the losers in a case like this are people who believe in God, because now you've got a Supreme Court ruling minimizing the belief system of many people. You've got justices saying God doesn't mean anything. God's a patriotic word. God doesn't have a religious connotation. And that waters down religion. So to answer your question, there have been efforts, and some of those efforts have stopped intentionally because the direction that the Supreme Court was waving a flag saying, we will not side with you. So it's sort of, it's stopped momentum, and necessarily so from the standpoint of we can't win right now. And I think when at some point in America's history or future, we will have maybe a better Supreme Court where these issues will, or a better Congress. Maybe it's time to petition Congress to change that again. It is legislation after all. So I will end today's session with that, and I look forward to talking to you on the next Legal Tuesdays.